Ms. Reed and Mr. Glick, did you guys have opportunity to speak to each other?
Yes, Your Honor, we did have an opportunity to speak with one another. I do believe we have a resolution to this matter. We would have to submit our stipulated order and our mortgage at a later date. We do have one individual who is deceased that we would like to remove from the mortgage just to make sure that it can be registered appropriately. So I will withdraw the motion to set aside the default, and we will in turn enter a stipulated agreement within 7 days.
Is that correct, Mr. Glick?
Well, yeah, Judge, just so the court's aware. So while we were waiting for the case to be called, I received some settlement documents back that, were provided a while ago, but the defendant hadn't signed. And they were signed with an Adobe PDF signature, not an actual signature. So there was a settlement agreement and a mortgage, and then an order setting aside the judgment and a dismissal that would be entered when the settlement agreement is satisfied and all the payments have come in. So the issue is that we need an original signature on the settlement agreement.
Really? Do you know that I sign things every single day that are legal and binding with Adobe now?
Well, and the other thing is that the mortgage needs
to be noted. The bank accepts them too.
I'm sorry?
It's fine. I said, and even the bank accepts things like that. I sign search warrants. I order people to do all kinds of things with a virtual signature. Just saying, but fair enough. So you want some time. I don't have a problem with that. I'm going to make a notation that the parties are to enter, send in a stip in order.
Well, Judge, what I was saying was, and also the other thing is the mortgage needs to be notarized. So there's no way around that one.
That's a different issue. The notary, the notary is a different issue.
But Judge, the settlement agreement calls for payments over time, and when the final payment is made, then the order setting aside the judgment and dismissing the case is going to be.
All I'm going to do is write that you're going to submit an order. I'm not going to put a time frame on it. And if we don't hear from you like in 30 days, we'll put it on a calendar for a lack of progress.
Well, what I'm saying though, Judge, is that there's already been a judgment in this case. There's not going to be any order entered until all the settlement payments are made, which could be a year from now. That's all I'm saying to the judges. We're not planning on submitting anything anytime soon.
Okay.
And I was under the impression that the order would be held in abeyance until my client paid everything off. I did think the order would be entered, but if it won't be entered, the order would say that the lien would be set aside and the judgment would be dismissed once payments were made.
Well, why don't you submit something under a 7-day rule, under the 7-day rule that says that?
That's what I plan to do.
Well, Judge, that's what I'm saying. We're not dismissing the case now. We're dismissing the case.
But you're not listening to what she said, that it's going to be held until that time happens.
It's going to be held by me, Judge, in escrow. That's the agreement.
I can put escrow.
No, I meant that our case is going to be held in abeyance for up to whatever, a year or whatever. I didn't mean the money.
Right, but it's not in abeyance. There's already a judgment. The case is over.
And you're going to dismiss it at a time in the future.
Correct.
Correct. That's exactly what she said.
Right, but I'm not going to submit an order now saying this case is going to be dismissed in the future.
No, counsel, Ms. Reed said, I'm going to file a 7-day that basically memorializes what the agreement is, with the understanding that if A, B, and C happens, then at some point in the future, when those conditions have been met, there's going to be a dismissal.
That's not the agreement, Judge. I understand what you're saying. That's not.
Please, Mr.
What I'm not understanding, Judge, is that's not what the agreement is.
I thought that. What is your understanding?
You said when the payments are made, it could take a year, then I'll dismiss it. Is that what you started by telling me?
Judge, we have a settlement agreement that has the terms. It's private. It's not going to be filed with the court. We're not going to have once A, B, and C is done. We have an agreement that's a private document. I'm going to hold a judgment in escrow. And when the settlement agreement has been complied with, then we're going to dismiss the case. And if it hasn't been complied with, we're going to continue. It's a forbearance agreement, essentially. And
right. And that's exactly what she said. I don't understand that how what I said is any different than what you said, except that you're saying that the terms are private. I don't care.
Because the answer is, Judge, we're not saying anything. Nothing's going to be recorded or filed with the court now. There's not going to be an order now. So that's the difference. We're not going to have an order saying, it's not an order of settlement that's got terms on it. It's a private settlement agreement. The case has already gone to judgment. It's already off the court's docket, and we've got a settlement
Well,
agreement.
it's obviously not off the court's docket because it's in front of me today.
Your Honor, all I can say is the agreement is what it is. And if counsel, it was provided literally months ago. If she wants to go back and read it, if we want to negotiate it, that's fine. But it is what it is. And what it is isn't saying we're going to submit an order now. That's all.
No, but it's set for, but Mr. Glick, today it is set for a hearing to set aside a default judgment. So it is set for a hearing.
Okay.
So
And
if I
counsel
decided to set aside the default judgment today, then it's a pending case. All she's doing is asking for the motion to set aside the default to be adjourned indefinitely till you figure out whatever A, B, and C of the settlement. And then at some point in the future, apparently, you know, if all the parties do whatever they're supposed to do, it's going to be dismissed.
And if I
Correct?
may,
She just said the motion, she's withdrawing the motion. She didn't say anything about holding it in abeyance for a year.
the judgment was to be held in abeyance. And Ms. Attorney Glick, if I've somehow confused you, I apologize. My understanding was that it would be filed with the court, but held in abeyance. And once my client paid the money, then the judgment would be dismissed. We are not in any way trying to excuse the money. I just thought the judgment would be dismissed once the money was paid. That was my understanding.
No one's saying anything different, and that's going to happen when the final payment has been made. It's not going to happen today.
Right. That's what we both said.
Fine. This all started because the court was saying, okay, I'll expect an order. I'm saying we're not going to get an order anytime
She
soon.
said that she was going to send a 7-day order that just memorialized so that we're not sending you a notice in 60 days saying this is, I mean, I understand what you're saying. If she's withdrawing her motion, then there is nothing that you need to submit to us until you file a dismissal within the year. So Ms. Reed, if you're withdrawing your motion,
Well, that was only with the understanding that a judgment would be submitted and something would be placed on the court's docket, allowing the court to have a time frame and for my client as well to be protected, that once the money is paid, then the judgment is dismissed. If I've somehow misunderstood, I would like to adjourn the motion for default or have the judge open the case again and argue the motion and have more time to negotiate with Attorney Glick. Attorney Glick has been very communicative with me. I just understood that the judgment would be entered with the court. I didn't realize he was simply trying to hold it in his office in abeyance. I thought I would do as Your Honor said, I'd place all of the terms in the judgment, not necessarily the amounts, but just letting the court know once this is paid, this matter will be dismissed. If that is not his understanding, I'm not willing. And again, if I misunderstood it, I'm not blaming Attorney Glick. I just thought that was what was going to happen today.
And I'm not sure on what counsel is saying would happen today. There's already a judgment. Is counsel saying there would be some type of an order setting aside the judgment today? That's not the agreement. So I'm not, so if we need
well, this is what I'm going to do. I'm going to adjourn the motion for the motion to set aside the default for 60 days. You guys figure it out within the next 60 days.
Judge, this has been going on for some time now.
All right, then you know what? Ms. Reed, go ahead and make your argument on your motion to set aside the default. Because apparently, I thought you guys had it worked out. I feel like we're all saying the same thing, but go ahead, Ms. Reed, it's your motion.
Your Honor, originally my client filed her complaint. She was in pro per. She had several different attorneys with whom she was consulting, but she did not, in fact, have a retained counsel as she does now. The original hearing, my client came to the hearing. However, opposing counsel could not get in the hearing, having technical difficulties, and the matter was adjourned. At the subsequent hearing, my client could not get in the hearing. I do believe she had it misdocketed. I don't think she couldn't get in. She had the wrong day. The matter was, in fact, dismissed at that time because my client could not get in the hearing. The matter was not dismissed on the merits. The matter was dismissed because my client simply failed to show at that hearing. In my motion, I indicated it would be no prejudice to the plaintiff, as when his client could not get on Zoom, the matter was adjourned and it was not dismissed. So I was simply asking for that same liberty, that the motion for the default judgment to be set aside as it was entered, because my client could not and did not show up to court that day. She was without counsel at that time as well. Therefore, she didn't have anyone representing her interests. I am here, I am litigious, I am prepared to represent her interests, and I will make sure that I make all Zooms. And again, Your Honor, the plaintiff isn't prejudiced in any way, as we offered him that same liberty when he could not, in fact, get onto Zoom.
And the issue of, go ahead, response, Mr. Glick.
Well, Your Honor, the defendants didn't offer me anything. I think what they're saying is the court rescheduled a pretrial conference that I wasn't able to appear on. Frankly, I did see that entry in the court's docket, but I don't have any recollection of missing a hearing. But it sounds like counsel's sole argument is, hey, we should be afforded the same courtesy. You missed a hearing and the case wasn't dismissed. Well, as I indicated in my motion, the defendants were extended the same courtesy, if not more so. The court didn't when they failed to appear for a hearing. And frankly, the court, we were on a June 23rd hearing that both parties were present for. And the defendant acknowledges, the court gave us a new date at that hearing. We were all advised of the new hearing. It's not as though they're saying that they didn't receive a notice. They're saying they wrote it down wrong. Well, when they didn't appear, the court didn't just enter judgment against them. The court asked me to submit a 7-day order. And so I submitted a 7-day order on September 9th, which would have made it, had it be entered on, I guess, the 16th. They actually had until the 25th. So they didn't show up on September 9th. They didn't cure that. They didn't contact me or contact the court or file anything. When they received my notice of presentment, they similarly didn't do anything. And then when the judgment was entered, they still didn't do anything. Now, aside from that, as this court is aware, the court rules require good cause and a meritorious defense, and neither one of them have been shown. Calendaring issues are expressly exempted. It says the cases I've cited say that calendaring problems are not good cause. But even if they were good cause, there's been no meritorious defense shown. The affidavit provided, as I indicated in my motion, only says we have a meritorious defense. And I've indicated in my motion the law that says that's not good enough, and you can't have good cause or it's one or the other, it's both. And not only have they not provided any good cause whatsoever, but my response to their motion was emailed to counsel 12 days ago. And they still didn't update anything and provide an affidavit of meritorious defense.
Ms. Reed, what is the meritorious defense?
My client has condensation in her laundry room. The roof is actually swelling, sweating, and leaking, which would mitigate the $18,000. I'd like to respond to the fact that my brother counsel is indicating that we didn't update our motion. I thought we had resolution when we agreed to enter the judgment and hold it in abeyance. We just had a different understanding. So the reason I didn't amend my motion and update my motion is because I thought the matter was in fact resolved. Also, the Supreme Court, and it's been written in my motion, has indicated that if there is no prejudice and a matter has not been litigated on the merits, the courts can, at its discretion, set aside a default. But we do have a meritorious defense. And lastly, Judge, I was not, just for the record, again, my client was in pro per. I was not the attorney of record when the default was entered. She came to me afterwards, and I picked up the case, and I began to try to assist her and litigate the case. But her laundry room is leaking. She still has condensation. I emailed my brother counsel that a short time ago, once I saw during this Zoom hearing that we were not going to resolve. I was just going to try to talk to him and resolve those matters off the record. But now that we're saying we're not in agreement, I would like for Your Honor, to set aside the default or at least adjourn it that we can solidify our agreement a bit more, because I thought we were resolved is the only reason that I did not update the pleadings.
Well, and Your Honor, if I could respond,
Yep, go ahead.
we had agreed to a settlement months ago, and counsel had me go to the trouble of preparing settlement documents, which they then didn't sign and tried to renegotiate and yada, yada, yada. And then a month ago, after this motion was filed, I got another call saying, okay, we're agreeable now to the settlement. Please update the documents and send them over to me, which I did. And I withdraw my motion. Well, Judge, I went to the trouble of doing that, despite promises that the motion would be withdrawn when I did that, and that it would be signed under the terms that we agreed to. And of course, what do I get? I don't get, the motion isn't withdrawn. I get a counteroffer, and they refuse to sign these documents, and they don't do anything until I literally got the signed documents we're talking about today, Judge, at 10:09, 9 minutes after we're in this hearing. And the mortgage isn't notarized. The settlement agreement is a PDF document. So I don't have any useful documents.
Your Honor, if I may, again,
I
as Your Honor
wasn't.
said, I'm sorry, you weren't done.
That's fine. Go ahead.
All during COVID, all during the pandemic, I have been signing document PDF, Adobe. The only reason the document wasn't notified, my defendant, my client works for Highland Park Court. She planned on getting it notarized when she went to work today, but the courts closed because it was a snow day. And what my brother, so she couldn't get it notarized, but the plan was for the mortgage to be notarized. I've never had a problem signing in Adobe, so I didn't think that would be a problem today, specifically because of the pandemic. And lastly, in terms of me offering counter offers, that is true, Your Honor. I was trying to negotiate for my client. I did send over a counter offer. This, my client is looking at her budget. She can't afford this. Can we decrease it? My brother counsel said, no, we can't decrease it. So I wasn't sitting on it, just letting time go by. We were
Well, that enough. Apparently, I don't know if you guys can work out a settlement in this case or not. That apparently there's been some breakdown on both sides, and I don't know what the issue is. But I am going to find that there is good cause and there is a meritorious defense. I'm going to set aside. I'm going to grant motion to set aside the default. I'm going to set it for a pretrial in 3 weeks on March the 9th at 11:30. If you resolve it, if you don't, I will. So I'll see everybody in 3 weeks unless you guys have this resolved.
I'm not sure what that means, Judge. If we resolve it, if we don't resolve
it. If you
it.
end up coming up with a settlement, then if you don't resolve the case, then the case moves forward. And at some point I have a trial and I resolve it, Mr. Glick. That's how it works.
Okay, that's understood. So at the pretrial, Judge, will we have an opportunity then to ask for discovery and have a scheduling order and all that?
Yes.
Okay, perfect. So we're at square one. Got
Correct.
it. Okay.
And I didn't want to put it out. I hear what you said about it going on for a long time. So I didn't want to give you an April or a May date. I wanted to give you a date in 3 weeks so that we can move this along.
And just for the record, Judge, because if in case we file an appeal, I'm still confused about how the agreement allegedly was signed this morning and they were ready to go, but yet it's not agreeable and it's not what they understood it to be. I'm not clear on that.
And you know what? The record speaks for itself, and you can get a copy of the transcript if you're going to do an appeal. I have all these other people waiting, and we've spent enough time on this. The only thing that was before me today was the motion to set aside the default, and you both turned it into something else. And so whatever your understanding was or wasn't, I don't know. The only thing I knew when I brought both of you in was that it was set for a motion to set aside a default.
Okay, and Judge, under the court rules and as asked for in my motion, if the court is inclined to set aside a default, the non-moving party can ask for costs. And of course,
that's right. And I'll hold the motion for, if you want to file a motion for costs, I'll hear it.
Thank you, Judge.
All right. You're
you,
all
Madam.
set. Have a good day.
Thank you, Judge.
Thank you.